So we will be confining ourselves only with regard to questions pertaining to the Code of Civil Procedure, and some Limitation Act questions are there, and only one I saw pertaining to Negotiable Instruments Act. So because the time is short, first we will complete the questions. We will go year-wise, in which the questions pertaining to CPC and limitations are there. We will go on discussing with that. And as I have also informed you, always remember the marks allotted to that particular question. And you should always go through the instructions before you start reading your question paper. First you should see what are the instructions, and then after seeing the question papers, you please select the questions you know very well. You answer first those questions, the answer of which you know very well, so that you can save much time. Thereafterwards, you will go to other questions which you are doubtful or not familiar with the questions pertaining to any enactment. Now, to start with, you please take 2015 question paper pertaining to the post of district judges, 30th August 2015. Straight away you come to Roman 2, question Roman 2. So there you will see the marks allotted is only 1 marks to each of the questions. It consists of nearly A to G. Most of them are pertaining to the Code of Civil Procedure only. Of course, it can be connected to Evidence Act also, but we will not go on to that aspect. We will confine only to the Code of Civil Procedure. So now, A, production of documents in evidence. So I will give the details, but you need not write those details in your answers because the marks is only 1. For which you have to go to order 7, order 8 and order 13 of the Code of Civil Procedure. All these provisions deals with regard to production of the documents. Earlier to amendment to the Code of Civil Procedure of 99 and 2002, we used to invoke order 13 only to produce any document. But now it is not so. After the amendment, we are bound to produce the original documents along with the plaint and along with the written statement. Of course, if you are not able to produce at the time of filing of the plaint or written statement, with the permission of the court, you can produce the documents afterwards. But you have to give reasons why you are not able to produce the documents earlier. And they have also mentioned in those provisions that is not applicable to the documents which will be produced in confronting a witness in cross-examination. Even though you have not produced certain documents along with your plaint or written statement, law permits us to confront a document even though that has not been produced. Now, for this your answer will be simple. If the plaintiff wants to produce the documents in view of the order 7, he has to produce all the documents on which he relies, original documents, along with the plaint. Similarly, the defendant, along with the written statement, with the list of documents, both they have to produce. And if there is a delay or if they could not produce along with the plaint or written statement, then along with an application, again under order 7, if the plaintiff wants to produce, or 8, if the defendant wants to produce belatedly with sufficient reasons, along with the list of documents he has to produce. Immediately after framing of the issues, the parties are required to produce the list of witness and documents. If you write this, that is enough for this 1 mark question. Next, B, objection regarding marking of a document. For this section, order 13, in view of amendment to order 7 and order 8, we are not making use of the order 13, but order 13 will be made use of after production of the document. Now, for that you should go to other questions, that is objection regarding marking of a document, that is B, question B, impounding of a document, that is C. Of course, proof of a document is covered under the Evidence Act, we will not go to that. And C, court questions. This is covered under order 18, whereas question B, that is objection regarding marking of document, impounding of document, are covered under order 13. But question number E, that is court questions, is covered under order 18, if I am right, rule 10 and 11. So, what order 13 says is, after documents are produced, how those documents have to be treated. There it says the court can reject the irrelevant documents. If the documents are irrelevant, court has got power to reject it. At the same time, if any party wants to produce in the evidence to mark any document, the opposite side should always be very careful. Careful in the sense whether those documents are relevant or not for the purpose of the case, whether those documents are original or copies, whether those documents are compulsory registerable or not under section 17 of the Registration Act. These things they should think. They will give them a right to object for production or marking of the documents. Even though the documents have been produced, we can, or the opposite side can always object to the marking of the documents. Of course, the courts have also taken the view that merely marking of the documents will not make those documents to be relied upon. It requires proof also. They are required to be proved. Merely marking of the document need not be taken for granted and should be relied on. No. Now, as we know that only original documents should be produced and marked. Otherwise, again you have to go to the Evidence Act, how the secondary evidence has to be produced all those aspects. If there is no foundation laid down by the party, court will not permit any party to produce a secondary evidence like certified copies. Only primary evidence, that is the original documents, have to be produced and marked. If party wants to mark any document which is not original, we can object. The opposite side can object and the court naturally will permit. But certain times original cannot be produced. For that, we can give an example. The plaintiff has sent a notice of termination of lease to the defendant. So the original will be with the defendant. Plaintiff will be having only copy of the notice. So then court cannot say to the plaintiff, no, you should produce the original. No, because he is not in custody. Because the original has already been sent to the defendant. So barring such exceptions, only original should be produced and we can object if the original is not produced. Next thing is whether the document produced is required to be on sufficient stamp duty to be executed and compulsorily registrable or not. So that is why the opposite party should always be careful when his opponent is producing and marking the documents. ಎದುರುಗಡೆಯವರು ಪತ್ರಗಳನ್ನು ಮಾರ್ಕ್ ಮಾಡಬೇಕಾದ್ರೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಬೇಕಾದ್ರೆ ನಾವು ಯಾಕಿರಬೇಕು ಅನ್ನೋದಕ್ಕೆ ಇದೇ ಕಾರಣ. ಅವನು ಯಾವ ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಡ್ತಾ ಇದ್ದಾರೆ ಆ ಡಾಕ್ಯುಮೆಂಟ್ ಒರಿಜಿನಲ್ ಹೌದೋ ಅಲ್ವೋ, ಕಂಪಲ್ಸರಿ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಮಾಡಬೇಕಾಗಿತ್ತೋ ಇಲ್ವೋ, ಸಫಿಷಿಯಂಟ್ ಸ್ಟಾಂಪ್ ಡ್ಯೂಟಿ ಇತ್ತೋ ಇಲ್ವೋ. So therefore, if the document which is required to be compulsorily registered, it cannot be marked. Section 17 makes very clear, Registration Act, any document pertaining to an immobile property, the value of which is more than 100 rupees is compulsorily registrable. So court cannot consider that document if it is not registered, which is required to be registered under section 17. For example, sale deeds. So lease deed, as we all know that they will make only for 11 months. Why? To avoid the registration. The main purpose why the lease deeds are made for 11 months is to avoid the registration, because section 17 says if a lease deed is for more than 12 months it is compulsorily registrable. ಅದಕ್ಕೆ ಎಲ್ಲ 11 ತಿಂಗಳಿಗೆ ಮಾಡ್ಕೊಳ್ಳೋದು. But that does not take away the provisions, applicability of the provisions of the Stamp Act. Those documents, even lease deed for 11 months, should be on a requisite stamp paper. Only registration is dispensed with 11 months. ಹಾಗಾಗಿ ಅದು ಬಹಳ ಮುಖ್ಯ ಆಗುತ್ತೆ. So there are certain documents which are exempted from compulsory registration. That is, as we all know, that will need not be registered. So ಆ ಟೈಮ್ನಲ್ಲಿ ದಿ ಪಾರ್ಟೀಸ್ ಕ್ಯಾನ್ ರೈಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್, ದಾಖಲೆಗಳನ್ನು ಗುರುತಿಸುವುದಕ್ಕೆ ಎತ್ತಿದ ತಕರಾರಿನ ಬಗ್ಗೆ. ಸೊ ದಿ ಪಾರ್ಟೀಸ್ ಕ್ಯಾನ್ ರೈಸ್ ಅಬ್ಜೆಕ್ಷನ್, court will upheld or refuse to accept. ಉದಾಹರಣೆಗೆ, if the plaintiff wants to produce the notice issued by him to the defendant, if the defendant objects, no, that cannot be marked, it is a copy, court can overrule that by giving a reason. So court is required to consider the objections. For raising the objections, certain times court also has got power to say that mark subject to the proof. Subject to proof, the document will be marked. That which we are all aware of. Next comes impounding of document. This is also under Order 13, Rule 8. If a document is executed on insufficient stamp paper, then the opposite party has got right to object for marking of that document. Court will also object, and if the party wants to rely on that particular document which is insufficiently stamped as per the Karnataka Stamp Act in our state, the court has got power to impound under Order 13, Rule 8. What do we mean by impound? Impound means court will take the document and refer the same to the Registrar of Stamps to ascertain what is the stamp duty on which this document could be executed, and he will give the report what is the requisite stamp duty for that particular document plus duty and penalty. 45A of the Stamp Act, Karnataka Stamp Act, deals with regard to that, which you are all aware of. So the authority has got power to impose 10 times of the deficit stamp duty as a penalty, maximum. ಅವನೇನಾದರೂ ₹1,000 ಕಡಿಮೆ ಸ್ಟ್ಯಾಂಪ್ ಡ್ಯೂಟಿ ಮೇಲೆ ಮಾಡಿಕೊಟ್ಟಿದ್ರೆ 10,000 ಅವನು ಡ್ಯೂಟಿ ಪೆನಾಲ್ಟಿ ಕೊಡಬೇಕಾಗತ್ತೆ ಮ್ಯಾಕ್ಸಿಮಮ್ ಇಫ್ ಯು ವಾಂಟ್ ಟು ರಿಲೇ ಆನ್ ದಟ್ ಡಾಕ್ಯುಮೆಂಟ್. ಟಿಲ್ ದೆನ್ ದ ಕೋರ್ಟ್ ವಿಲ್ ನಾಟ್ ಪರ್ಮಿಟ್ ಹಿಮ್ ಟು ರಿಲೇ ಆನ್ ದಟ್ ಡಾಕ್ಯುಮೆಂಟ್. ದಟ್ ಈಸ್ ಹೌ impounding of a document by the court. Then come to now E, court questions. Order 18. Before we venture upon that question, here itself we will also, because Madam asked with regard to 13, Order 13. Order 13 also deals with regard to return of the documents. When the court can order for return of the documents, it says that if any document is rejected as irrelevant, court can order for return of the document. Otherwise, till the case is disposed of, court will not order for return of the document. Even then, Order 13 says the parties have to produce the certified copies of those documents to take back the original documents produced by them. One interesting point which I also came to know very late with regard to return of the documents. It says if the value of the document is lost by the time the court has decided the case, then there is no need to return the document. ಕೇಳಿದ್ರಿ ಇದು ಯಾವಾಗಾದರೂ? ಹ್ಯಾವ್ ಯು ಹರ್ಡ್ ಅಬೌಟ್ ದಿಸ್? If the document which has been produced has lost its value by the time the court has decided, ಕೋರ್ಟ್ ತೀರ್ಮಾನ ಮಾಡೋಷ್ಟೊತ್ತಿಗೆ ಆ ದಾಖಲೆ ತನ್ನ ವ್ಯಾಲ್ಯೂನ ಕಳ್ಕೊಂಡು ಬಿಟ್ಟರೆ ಅಂಥ ಸಮಯದಲ್ಲಿ ಇಟ್ ಕೆನಾಟ್ ಬಿ ಆರ್ಡರ್ ಟು ಬಿ ರಿಟರ್ನ್ಡ್. ನಾನು ಯೋಚನೆ ಮಾಡ್ತಿದ್ದೆ ಯಾವುದು ಅಂತ. ಒನ್ in P&S case, a will was required to be returned by filing an application under Order 13. Then the office said, no, by virtue of Order 13, will has lost its because it has been probated on the stamp paper. So the original will be gone. That cannot be given. Original will be losing its character because it is engraved in the stamp paper by giving the probate of particular that will. So under such circumstances, very few of course. So that is one of the provision which you may remember. Next comes the court questions. Order 18 deals with regard to hearing of the suit. Once the evidence starts, Order 18 comes into picture, where it says plaintiff has right to commence, or the person on whom the burden lies has to lead evidence. ಫಸ್ಟು ಮೊದಲು ಯಾರು ಸಾಕ್ಷಿ ಕೊಡಬೇಕು ಅಂತ ಹೇಳಿದ್ರೆ, ಯಾರ ಮೇಲೆ ವಿವಾದಾಂಶದ ಹೊರೆ ಇರುತ್ತೋ ಬರ್ಡನ್, ಅವನು ಪ್ರಾರಂಭ ಮಾಡಬೇಕು ಅಥವಾ ವಾದಿ. ಬಟ್ ಇಟ್ ಇಸ್ ಮೇನ್ಲಿ ದ ಪರ್ಸನ್ ಆನ್ ಹೂಸ್ ದಿ ಬರ್ಡನ್ ಲೈಸ್ ಹ್ಯಾಸ್ ಟು ಸ್ಟಾರ್ಟ್ ದಿ ಎವಿಡೆನ್ಸ್, ಲೀಡ್ ಎವಿಡೆನ್ಸ್, ಬಿಗಿನ್. Then it says, if the party wants to examine himself, he should examine first himself before he examines the witnesses. ತನ್ನನ್ನು ಅವನು ಸಾಕ್ಷಿಯನ್ನಾಗಿ ಮಾಡ್ಕೊಳ್ಳೋದಾದರೆ, ವಾದಿಯಾಗಲಿ ಪ್ರತಿವಾದಿಯಾಗಲಿ ಆದೇಶ 18 ಪ್ರಕಾರ ಫಸ್ಟ್ ಅವನು ತನ್ನ ಸಾಕ್ಷಿ ವಿಚಾರಣೆ ಮಾಡ್ಕೋಬೇಕು, ನಂತರ ಸಾಕ್ಷಿಗಳ ವಿಚಾರಣೆ ಮಾಡಬೇಕು, ವಿಟ್ನೆಸಸ್ದು. He has to examine himself first, thereafterwards witnesses. But if he wants to examine other witnesses before he himself examines, then he has to take the permission of the court. That is the law under Order 18 of the Code of Civil Procedure. And usually the court will record the evidence in the court language. In all states, the state language is the court language, not the English. That is how we, in our state, Kannada, Kerala, Malayalam, Tamil Nadu, Tamil. If the witness does not know the language, then the question of appointment of ಭಾಷೆಯನ್ನು ಟ್ರಾನ್ಸ್ಲೇಟ್ ಮಾಡೋನ್ನ ಅಪಾಯಿಂಟ್ ಮಾಡ್ಕೋಬೇಕಾಗುತ್ತೆ, ಕಮಿಷನ್. ಸೊ ದಿ ಕೋರ್ಟ್, while recording the evidence, be very careful. What actual answer the witness gives has to be recorded, because there will be a lot of changes. The answer given by the witness and the recorded by the court, it should not be. ಅವನು ಏನು ಉತ್ತರ ಕೊಡ್ತಾನೋ ಯಥಾವತ್ತಾಗಿ ಅದನ್ನು ರೆಕಾರ್ಡ್ ಮಾಡಬೇಕು ನ್ಯಾಯಾಲಯ, ಬಿಕಾಸ್ ಇಟ್ ಗಿವ್ಸ್ ಎ ಲಾಟ್ ಆಫ್ ಡಿಫ್ರೆಂಟ್ ಮೀನಿಂಗ್ ಆ್ಯಂಡ್ ಇಟ್ ವಿಲ್ ಹ್ಯಾವ್ ಇಟ್ಸ್ ಓನ್ ಎಫೆಕ್ಟ್ ಆನ್ ದ ಜಡ್ಜ್ಮೆಂಟ್. Similarly, when a particular question is asked and the court can object, no, it is not relevant for this case. So, anta sandarbhadalli, under such circumstances, the parties can request the court, no, you please consider my request and you pass appropriate orders on my request. The court is required to hear the advocate pertaining to that question. Then it has to give reason. If the court itself objects, why it is disallowing. If the opposite party objects, ಎದುರುಗಡೆಯವರು ತಕರಾರು ಹಾಕ್ಬೋದು. ನೋ ದಿಸ್ ಕ್ವಶನ್ ಕೆನಾಟ್ ಬಿ ಆಸ್ಕ್ಡ್, ಇಟ್ ಇಸ್ ನೋ ವೇ ಕನೆಕ್ಟೆಡ್ ವಿತ್ ದಿ ಕೇಸ್, ಇಟ್ ಇಸ್ ಮೋಸ್ಟ್ ಇರ್ರೆಲೆವೆಂಟ್. ದೆನ್ ದ ಕೋರ್ಟ್, ಕನ್ಸಿಡರಿಂಗ್ ದಿ ಅಬ್ಜೆಕ್ಷನ್ ರೈಸ್ಡ್ ಬೈ ದಿ opposite party, has to give its opinion with cogent reasons, and then certain ಕೇಳಿಸ್ತಾ ಇದೆಯಾ? ಸರಿ, ಓಕೆ. ಸೊ ಕೆಲವು ಸಂದರ್ಭದಲ್ಲಿ ಕೋರ್ಟ್ ವಿಲ್ ರೆಕಾರ್ಡ್ ದಿ ಕ್ವಶನ್ ಆ್ಯಂಡ್ ದಿ ಆನ್ಸರ್ ಗಿವನ್ ಬೈ ದ parties also, witness also. What is the question asked by the advocate and what is the answer given by the witness? Because the advocate may argue, no, that is not the answer he has given. So then, to clarify, under such circumstances, the court will record what is the question put to the witness by the advocate and what is the answer given by him. And court also has got power. This is exactly what it means. Under this question, see, ನ್ಯಾಯಾಲಯದ ಪ್ರಶ್ನೆಗಳು, apart from the advocates asking the questions on behalf of their parties, the court has also got power to ask questions if it is relevant. So it has got wide power. So for that, the parties cannot object. It is the privilege of the court, provided under Order 18, Rule 10 and 11 of the Code of Civil Procedure. So that is how we have to deal with regard to the questions and the evidence given by the parties under Order 13 and Order 18. Of course, Order 18 also is amended, as we all know that, where it says that now we are permitted to file the written arguments. We are also now permitted to file the affidavit in lieu of chief examination, and we are also permitted to seek for appointment of commission for recording of evidence. And most crucial amendment which the courts are not yet following or insisting, the courts have got now power to limit the duration of the arguments of the counsel. Court have got power under Order 18 after amendment of the Order 18 by the 99 and 2002 amendment. Fortunately, the courts are not insisting on that, but indirectly they will suggest, now you please come to the point based on your evidence, and all those documents we can look into. Like that, they will persuade the advocate to reduce their duration of the argument. Now, other two important questions, F and G. F reads like this question: what are the circumstances under which additional evidence is allowed in appellate court? G. What are the grounds for remanding the case by the appellate court? Here, the marks are more compared to the earlier questions. For F, 3 marks are given. What are the circumstances under which additional evidence is allowed in appellate court? For the G, what are the grounds for remanding the case by the appellate court? 2 marks are given. Now, these answers we will find in Order 41 coupled with Section 96, which deals with regard to appeals. Please remember, whatever may be the appeal, whether it is an appeal under Section 96 coupled with Order 41 against original judgment and decree, or it is an appeal against orders under Section 104 coupled with Order 43, or appeal by an indigent person under Order 44, or an appeal against appellate judgment and decree under Section 100 and Order 42. The procedure that has to be followed is one and the same, provided for first appeal under Order 41. ಇದು ನೀವು ಯಾವಾಗಲೂ ಜ್ಞಾಪಕ ಇಟ್ಕೋಬೇಕು. ಎಸ್ ಹೇಳಿಮ್ಮ. ಎಸ್ ಓಕೆ 96, that is pertaining to appeals against original judgment and decree. Appeal against appellate judgment and decree is provided under Section 100, Order 42. Appeal against orders is provided under Section 104, Order 43. Appeal by indigent persons is provided under Order 44. So, what we have to remember is, whatever may be the appeal, first appeal, second appeal, appeal against orders, appeal by or against indigent persons, the procedure that has to be followed is as provided under Order 41 of the Code of Civil Procedure. Same procedure ನಾವು ಫಾಲೋ ಮಾಡಬೇಕಾಗುತ್ತೆ. Because tomorrow as a DJ, you are going to apply these provisions. Appeal will come to you only. It may be MA against orders, appeal against orders, RA, ಧಾರವಾಡದ MA ಅಲ್ಲ, RA, the regular appeal under section 96 and order 41. The procedure in nutshell, you should know